Hi, I'm Sarah Kamak. I'm the General Counsel for the Cuyahoga County Board of Developmental Disabilities.
And I'm Rick Cirillo. I'm the Chief Clinical Officer at the Cuyahoga County Board of Developmental Disabilities.
We are here today to give you some of the basics of guardianship and an understanding of what it means and how it works. So what is guardianship? Guardianship is a legal relationship that gets established by the probate court where an individual has an authority and duty over another person or their property. That person is referred to as a ward. The reason for the guardianship being put into place is due to the ward's disability or incapacity. The probate court may determine that a person is incompetent if they are so mentally impaired as a result of a mental or physical disability that they are unable to make decisions for themselves or properly care for themselves or their property.
So what are some of the common reasons that a person would seek guardianship? Typically, there's a number of reasons, but one of the ones we see most often, one of the ones I think that is often the most clear-cut reason, is that the person does not have the ability to show informed consent for an important medical procedure or some other kind of procedure that's very important to the basic safety and well-being of the person. And some sort of determination has been made that they're not able to make that kind of decision without a guardian. So that's a very common reason why we would seek to evaluate for a guardian. Other reasons relate to the inability to comprehend or appreciate or make rational decisions that just result in significant threats to their well-being. These oftentimes are a little bit trickier in terms of deciding whether or not we should move forward because, as it is, oftentimes people do make bad decisions and it doesn't necessarily equate to needing a guardian. But this is a process where typically teams at Cuyahoga DD look through the details of the situation and try and make a reasonable decision as to whether or not we should even attempt to request a guardian. Now, those kinds of decision problems that may be related to intellectual disabilities, but they could also be due to other conditions. For example, an autism spectrum disorder might be interfering with the person's ability to make appropriate decisions. Also, it could relate to mental health conditions. We certainly have many folks that we work with that have significant mental health conditions. So something, for example, like a bipolar illness that's poorly treated might result in a person going through periods where their thoughts become very racing and expansive. They might break with reality. They might not be able to make decisions in their own best interest when in those periods. So these are the kinds of things that we would typically look at. Finally, one of the areas that sometimes results in seeking a guardian is when people have very significant trauma histories. As is well known, when a person has very significant trauma history, typically during the childhood years, but sometimes into the adult years as well, this can often cause systemic dysregulation of their ability to think clearly, to control their emotions, and can result again in decisions that get made, behaviors that happen that really put the person at risk. So again, it is one of those areas where we have to think very carefully about, is this something that we would pursue or not pursue? But people with significant trauma backgrounds are another group of folks that will oftentimes need a guardian in order to keep them healthy and safe. Cuyahoga DD does have psychologists on staff, and we routinely provide these kinds of evaluations. The other kind of report that the court will ask for is the guardianship report, as it's called. So these are done every 2 years for parents who are guardians or for non-absentee guardians. And with those can be completed by a psychologist or a medical doctor. They can also be completed by what's known as an intellectual disability team. So there's fewer requirements as to who can complete those. But Cuyahoga DD routinely provides both of those kinds of evaluations. Typically, the way we learn about these is that the support administrator for the individual makes a request to the behavioral health department for the evaluation. Usually this is because the team is aware of some kind of need, some sort of issue arises which leads the team to believe that the person may need a guardian in order to remain safe and healthy. In other cases, it's because a family member or an existing guardian has asked for help to get this completed, and then they will ask the support administrator, and the support administrator will approach us, and then we will get the process started. So, there is no cost to have these completed. We do these, again, often, and there's never been any cost for them. It is a requirement, however, that the person be board eligible. They have to be eligible for our services for us to do this. Typically, what this will involve then is we will do an interview of the individual and try and get to know them and get a sense of what their level of understanding is and so on. We will review the person's record, try and understand what's taken place up to this point, what is the condition that caused them to be eligible for our board services to begin with, any other kinds of information that might play into their ability to make decisions on their own behalf. We'll seek out other collateral sources of information. If the person's parent is still involved, we'll almost certainly talk to that parent to get additional information about the individual's needs and level of functioning. And under certain circumstances, if there's a particular need, an expedited evaluation can be requested, but it does require that there is really unusual circumstances that will not allow for the usual time period to go by that would be required to complete the process. The reports, they essentially conclude with a recommendation to the court as to whether or not guardianship should be established or continued or denied. Some of the content that we would include in these evaluations relate to some of the medications, the diagnoses that the person has, any kinds of test scores that would be relevant to the person's ability to make decisions would be included, observations of the person's mental status. So for example, things like problems with thinking clearly or intellectual ability, or if there was a serious mental health condition that caused their information processing to wax and wane and become impaired at various points. It's all relevant information in terms of how well a person can manage their own affairs, and so we would include that. Physical impairments, special characteristics of the individual would also be included. And then we would speak to the person's ability to manage their own finances. We would give an opinion as to whether or not the condition that they have is likely to remain, or perhaps it could be reversed over time. And so through that process, we develop this document, and then we make a recommendation to the court that either guardianship be established or continued or denied.
So there are several different types of guardianship that can be granted by the probate court. The first is a guardianship of the person. This is what we see most often. This gives the guardian the right to make personal decisions for the ward, but it does not give them authority over the person's assets. That is called a guardian of the estate and is a separate type of guardianship that gives the guardian responsibility for managing the assets of the ward. The court could also grant a guardianship of the person and the estate, and that gives the guardian authority and responsibility over both the ward's personal decisions and their monetary assets. The most common for the people that we serve is the guardianship of the person. In these cases, the probate court is considered the superior guardian, meaning that the probate court itself has authority to manage the guardianships. If there's any kind of issue or problem with it, with the guardianship, the probate court will be in the position to review and potentially remove a guardian if there's an issue. Generally speaking, a guardian may not be a paid provider for the individual for their own ward because of a concern about conflict of interest. But if the guardian is a family member, they can get approval from the probate court to allow them to be both a guardian and a paid provider. The responsibilities and expectations of a guardian are pretty broad. You are taking authority over someone else's decision-making process, so it's a big deal. There are some formal requirements and then just some general requirements. So the formal requirements are that there be a one-time 6-hour education course that's taken by the guardian before they are appointed. There's also a 3-hour continuing education course that's required of professional guardians like AFSI or anyone else who's a paid guardian. We don't typically have a lot of paid guardians other than AFSI in our world. The other requirements are to meet with the ward as needed, but at least quarterly, in person, and to communicate privately with the ward so that they understand their needs and desires. The guardian is expected to oversee the general health and welfare of the individual to make sure that their housing is safe, that their care is appropriate. They need to see that the basic everyday needs are being met. The guardian is charged with decision-making about transportation, medical care, housing, personal care. All of these things are under the authority of the guardian. And then there are also some reporting requirements that need to be met with the probate court. That includes, as Dr. Cirillo mentioned, the guardian's report that has to be filed every 2 years. That is something that, as he explained, we can help with issuing the expert evaluation that goes along with the guardian's report. There is also a way, after a couple of guardian's reports have been filed, if the condition is expected to be ongoing and not change into the future, the guardian can request that the court waive that requirement for the ongoing expert evaluation, and the court can approve that, so that you wouldn't have to continuously file an expert evaluation going forward. The process for becoming a guardian. So the prospective guardian files an application for guardianship, an affidavit of guardian applicant, and an expert evaluation with the probate court. There's a filing fee of $175 that needs to be submitted with that application, and all the forms are available on the probate court's website. For Cuyahoga DD volunteer guardians, that's not necessarily family members of people we serve, but we do have a volunteer guardianship program, and for those people who are part of that program, the application fee is waived. It's important to note that the affidavit must be notarized, so that before it's submitted, it has to be notarized. And expert evaluations have to be completed by a licensed physician or a licensed clinical psychologist. And again, that's something that our staff can help with. Once that is filed, the probate court will assign an investigator to the case. That investigator will go out and meet with the prospective ward. They'll also make sure that the next of kin are notified so that there are no concerns that someone is applying for guardianship who shouldn't be. The probate court will then schedule a hearing to go over the investigator's findings, hear from the prospective ward and the guardian, and ultimately make a decision about whether or not to grant the guardianship. If the court does determine that the guardianship is appropriate, they will then issue letters of guardianship which go out to the guardian in the mail so that they can use those to show doctors or anyone else who they need to prove that they are appointed as the guardian. The guardian reporting requirements, a guardian is required to file a guardian's report every 2 years. The probate court will send out a notice when the guardian's report is due, and you would have 30 days from the time that you receive that notice to file the guardian's report. The guardian's report is basically a form that's available from the probate court website. It would include a statement of expert evaluation if that requirement has not previously been waived by the court. And both of these forms are available on the probate court website. You can just submit those by mail to the probate court. If an extension is necessary, you can typically contact the probate court and let them know that you would need an extension on that filing deadline, and they would typically approve it. Failure to file the guardian's report can result in being removed as the guardian, and so you want to really make sure that you keep up with those reporting requirements. There are some less restrictive alternatives to guardianship that exist for individuals who maybe just need a little bit of help in a certain area of their life, but maybe don't need full decision-making abilities taken away from them. These would include a power of attorney, which is a voluntary appointment of a person as a decision maker to assist with matters. These powers of attorney don't require any probate court approval, so they can be revoked at any time by the individual. So a person could choose to put a power of attorney into place, and then later decide that they no longer want that to be in place, and they can take back that decision-making authority. There's a couple of different kinds of powers of attorney. There's a financial power of attorney that allows a person to assist with financial decisions. There's also a healthcare power of attorney. There are some very basic forms available online, or if you contact us, we can help you find those. And those would detail like the breadth of the decision making that the person is giving to you. Another option is a chosen representative. This is this is similar to a power of attorney. It's a voluntary appointment of an individual to assist with decision making as it relates to DD services specifically. A payee is another option that you can use. A payee is a person, it can be appointed by either the individual themselves, they can choose to have a payee appointed, or their guardian can choose to have a payee appointed. This payee is responsible for using the individual's income to meet their needs and ensure that their bills are paid. So essentially, when a payee is appointed, all of that person's income would go to the payee, and the payee would be responsible for making sure that their bills are paid and that any additional funds are going to them in a way that can be managed to meet maybe some elective needs that they have. Appointing a payee does not require probate court approval. A representative payee is specific to the Social Security Administration. That person or organization is appointed by the Social Security Administration directly to manage a person's Social Security benefits. This also does not require probate court approval, but is another way to just make sure that somebody's finances are being properly managed. And then a limited guardianship is another option. This is a guardianship that can be limited by time or scope. So this would still go through the probate court. You would file the same forms that you would for a typical guardianship of the person or estate or both. But you would note in the application that there's a limitation on either the time frame for which the person is appointed to make decisions, or the scope. So they would only be allowed to make certain types of decisions for that person. This again would be something that goes through the probate court. So it is official, but then it doesn't get terminated by the court. It kind of gets terminated just by the request itself. So with a time limitation, it would terminate on a certain date. With a scope limitation, it would just limit the person to making certain decisions. For instance, if somebody only needed help making medical decisions, that would be something that could be noted in the guardianship as a limitation. Certain rights are retained by an individual who is under guardianship. These include sort of basic fundamental rights that can't be taken away, including the right to be treated with dignity and respect, the right to be safe and live in the least restrictive setting available, the right to vote. For instance, a guardian doesn't get to go to the polls and take over someone's ballot for them. That ward would still have the right to make that decision. Privacy, including healthcare information. So a guardian cannot disclose medical information to someone against the will of the ward unless it needs to be done for a health or safety reason. Religious and spiritual freedom. So an individual under guardianship can still practice any religion that they want to. Some medical procedures, particularly those relating to reproductive rights, such as abortion or sterilization, those rights are retained by a ward under guardianship, and those decisions can still be made by the ward without the guardian's approval. And a ward can ask the court to review the presumed inability to make a decision. So meaning the ward has a right to always go back and ask the court to determine whether they require a guardian still. In general, all legal and civil rights under the Ohio and US Constitution remain with the ward unless they're explicitly taken away. There's also a right to counsel, but for the ward at the time that guardianship is put into place. So that's another right that exists. And the ward can just ask the court at the time of the guardianship filing for representation, and the court will appoint an attorney for them. Some frequently asked questions that we get regarding guardianship are, is it possible to appoint a successor guardian to take over if the current guardian can no longer serve? This is very common, especially with parental guardians who may be getting on in age or have health concerns of their own. and they wanna make sure that, there's a person that's ready and waiting when they can no longer serve as guardian. Unfortunately, the court will not allow you to appoint a successor guardian before your guardianship terminates. But you can let your individual's support administrator or someone else at the board know who it is that you'd like to have serve as a successor guardian, and that way we can contact them if the time comes. But the court will not appoint or note any kind of successor guardian until the current guardianship is terminated. How is guardianship terminated? So a guardian may resign as the guardian. They can submit a resignation to the probate court for approval. They technically don't actually get removed as the guardian until the court approves the resignation. So just sending a letter to the court doesn't terminate it. The court has to make that determination. So your responsibilities will continue until the court makes that determination. The probate court can also remove a guardian for cause if they find that the person is not making good decisions for the ward. Or the ward may be able to ask the court to restore competency, meaning that the court would take a look again and see if circumstances have changed in such a way that the person no longer requires a guardian. Then that person could be restored to competency and the court may terminate the guardianship. What do I do if I think the guardian is not acting in the best interest of the ward? So this is a really important question because we do want to make sure that these relationships are not being abused. Anyone, including the ward themselves, can file with the probate court a notice saying that, things are happening that shouldn't be happening, and ask the probate court to take a look at the circumstances. The probate court would then schedule a hearing with all the parties to hear the evidence of what's happening and make a determination as to whether or not it's appropriate for the guardianship to continue. Once filed, the court will make a determination one way or the other, but there's no limitation on the number of times you can file, so it's not like if the court determines that the guardianship should stay in place, that's a permanent decision forever. If there are more concerns down the road, you can certainly go back and file with the court again. Thank you so much for your time and attention. We appreciate you wanting to learn more about guardianship. If you have questions, please feel free to reach out to your support administrator, to Dr. Cirillo or to myself, and we will be happy to assist you.